Welcome, everyone, to another episode of the CTO podcast. My name is Felix Vargas. I am the CTO of Security for CDI. Today, we're going to be diving into cybersecurity, and we're going to be discussing the new rules that the SEC released affecting publicly traded companies and requiring them to disclose cybersecurity incidents that are deemed material in nature within 4 business days. With me, I have our CISO and the lead of our vCISO program, Josh Moore. Josh, good morning. How are you, sir?
I'm doing well. How are you?
Doing great, man. I was traveling yesterday. Actually, I just flew in from Minneapolis, so I spent some time on Lake Minnetonka. So all good stuff. And let's jump right in, though. But before we do, actually, can you give a bit of a background on yourself, Josh, and your cybersecurity experience, what you do at
Sure.
CDI? Thank you.
Yeah, I've been at CDI for many years now. I got my start back in the 90s when I was helping build Linux systems and design networks. And of course, back then, that was the days that cyber attacks got big, right? There's Code Red, there's NIMDA, there's a bunch of stuff that started spreading, and I got interested and started working through that. That eventually became a security practice that I brought to a consulting firm. And then after that, I eventually landed here at CDI. So I've been doing security for a very, very long time.
And can you talk a bit about, our vCISO program and, how our vCISOs can help just,
Sure.
overall?
Yeah, so there are a lot of different approaches to security. vCISO is really here because some companies will lack security leadership, or they will have security leadership that has an expertise in a particular area, right? Like development security, and they may not know as much about attacks against infrastructure or cloud or something like that. So what we have are vCISOs that are available to meet with clients on a regular basis, to meet if there's an incident that we have to work through and talk about, to help provide strategic level advice, whether that's remediating vulnerabilities, which is where a lot of companies still have issues, to much larger concerns like does it make sense to expand into Europe or China? Right.
Right.
What's the implication of a particular contract for a new deal and things like that. So it's having experts on demand like we do for other technical areas inside
Right.
CDI, but this is security experts.
That's excellent. So basically, they're an extension of our customers' teams, helping with
Yes.
overarching cybersecurity strategy. That
Yep.
makes a lot of sense. And you mentioned vulnerability management and context, and I think that's a perfect segue into the new rules that have been. They're not necessarily brand new, but the newer rules, right, that have been
Yep.
released that organizations are looking to strategize around, which focus on cybersecurity incidents and whether they're material in nature. So, what's the background of this rule? Like before we get into the specifics, give our listeners an overview of what the rules are and why they matter. The title is pretty verbose: cybersecurity risk management strategy, governance, and incident disclosure. What does that mean?
Okay. So this comes from the SEC and it applies to public companies. So any company that is being basically regulated by the SEC. Today, if they're public, they have to follow this rule. There's an expectation that there'll be a couple of other rules coming out soon that will cover the rest of the market, right? Your investment advisors and whatnot. And the basic idea here is that we're now at a point where can, security issues can affect investment decisions. And the SEC's role is to make sure the market is stable and trustworthy. So they want to make sure at a very high level that if a company experiences a breach or even a concerning cyber incident, that it's properly disclosed to the investment community, right? And what it does is it brings in several requirements. It makes sure that companies follow a process for notifying the SEC and therefore the rest of the market about the specific security concerns, and it centers everything around the concept of materiality, which has existed for a long time in the financial markets, but is relatively new from a cybersecurity perspective. And it really involves being able to disclose when there's an incident and being able to disclose as part of the annual filings, details, light details, right, on how the organization manages risk, manages security concerns, and things like that.
Right. And I mean, if you look about, the rule, it looks like this is trying to encourage change, right? From where we were to where we should be, right?
Yeah.
What's the overall impact, would you say, right? Like what's the change? Where were we? Where are we going? And what immediate steps should organizations take in order to address these challenges?
Okay. So where we were was that companies had to disclose security incidents based on other regulations and contracts with customers and things like that, and it was a big mess, right?
Hmm.
You do it differently based on which data you're doing business, which state you're doing business in, or which state the data is in, and it gets messy because the U.S. doesn't really have a lot in the way of national level cybersecurity rules. Where it is right now is companies are expected to include the disclosures today if there is an incident, and they're expected to include in their annual disclosures details on how risk is managed. And we've seen some of them come out, and it has had an effect on the market. We've had the I believe it was Clorox that had a breach that they disclosed, and their stock took a hit. There was the big news with the MGM Casino and
Hmm.
Caesar's Palace, and they had to do some filings as well. And what's happening is it's coming out, the market's reacting. It's still too new to know what enforcement actions might take place.
Right.
But that's where it's going. And I see a question that I'd like to address before we jump back in.
Sure.
So the question is there an expectation that federal contractors will have to follow these cyber compliance guidelines? And the follow-up, they're asking about private companies and educational institutions for R&D. Okay, now, today, the rule that we have is through the SEC that affects public companies, so it does not impact private companies directly. If those private companies have contracts with public companies, expect to see those contracts start to require similar types of disclosures. We also have last year, the Critical Infrastructure Act of 2022 has similar requirements, and a lot of the specifics there are still being determined. But that's going to affect all of the critical sectors in the US, and those are chemical, commercial facilities, communications, critical manufacturing, dams, the defense industrial base, emergency services, energy, financial services, food and ag, government facilities, healthcare, public health, information technology, nuclear reactors, space systems are expected, and transportation and wastewater. And I know that's a lot, but the basic upshot is if you participate in the open market or you participate in business with the federal government, rules like this should be expected.
Right. And to my earlier point, right, I think that these rules make sense, right? Like when we think of, something being material, right?
Mhm.
And should we wait for a rule to be levied before we take action, right? And I feel like, we should as a cybersecurity industry, right, do
Mhm.
this proactively, right? And so
Right.
when we think of, something being material, I think of context. So what does materiality mean within cybersecurity? Is that a new concept of cybersecurity, or have we seen that before?
Yeah, it's a new concept from a cybersecurity perspective. It's not a new concept from a market perspective. The definition that most people use comes from a Supreme Court case a while back, where they defined materiality as a substantial likelihood that any particular fact would have been viewed by the reasonable investor of having significantly altered the total mix of information made available that they
Right.
use to make decisions around investment. It's clear that a lot of cybersecurity incidents would alter that mix. And from a responsibility to the investment community, disclosure is the way to go. The challenge is that absent a law requiring it, when you look at the total risk to the organization of disclosing versus not disclosing, you have a lot to calculate, right? If you don't disclose and nobody finds out that you didn't disclose,
Right.
then in some jurisdictions that's not an issue, and it's better for the organization. And a lot of lawyers have given advice along those lines. If you don't disclose and it later comes out that you should have disclosed, as happened with Uber and Uber's CISO, there's a big, I mean, it caused a lot of issues, a lot of concerns, where the SEC filed an action against that particular person individually. Um, so my rule of thumb has always been to err on the side of disclosure, because transparency is better, right? When you disclose, it tells your clients what they need to know, it tells prospects what they need to know, and it really drives internal action in ways that not disclosing doesn't. And what you want is you want a secure environment where problems are less likely to happen. And sometimes disclosing can drive that change.
That's perfect. So, what sort of preparations must companies undergo to meet these requirements? What are the different approaches that you would recommend?
Right. So the first thing that I think is important is to really socialize this concept of materiality. Whether that is just talking it through at team meetings or holding a more formal workshop to work through the materiality issue, but you want to have that understanding before you experience a material event. And the reason for that is that 4-day timeline, right? Once an incident has been determined as being material, you have 4 days to draft up the documentation and send it off to the SEC for your filing. And 4 days is not enough to learn what materiality is, right? If you have an incident and you determine that it's material at a later point, right? The SEC's guidelines suggest that as long as it's a reasonable time frame, that's okay. We don't know what reasonable means. Reasonable is going to be defined over the next few years as the SEC takes action against companies. So what I would typically recommend is doing some sort of workshop or tabletop to work through the materiality concern and really get that understood. Take a look at what data types you have or what business practices you have, that if an incident affects those, it's automatically material, right? Look at your incident management workflow and make sure that that's been adjusted so there's a branching path that would include notification of the SEC, or more likely looping in counsel who would make the determination around that notification. You want to do the same thing for your risk management process, because you can find that there are risks that are deemed material. This is not necessarily just incidents, right? If you determine that something material is going on, it should be disclosed. And then finally, you need market-facing descriptions of how the organization identifies and manages material risks, and how the management and board oversee the management of those risks. And that needs to be in the annual filing, which, if you file in December, is coming up pretty quick.
Right. So let's talk a bit about understanding, right, that an incident is occurring, right? So you
Mhm.
need the proper tools to even know that something happened, right? So what happens in the case where you actually don't know that you have been breached?
Right. So I'm actually helping someone with that right now. It's not an unusual situation, right? You what will often happen is you will get a notification, maybe from a tool, like an EDR type of tool,
Mhm.
or you will find, hey, there's weird behavior on this server or in this system. Increasingly, there are notifications from like Homeland Security or the FBI that say, hey, we just did an arrest and we found your data as part of the arrest. And you've got to go through and figure out what happened, right? So what it comes down to is, after the fact, it's hard, right? If you look at it ahead of time, you get the right tools in place, you get your EDR in place, make sure it's configured properly, make sure it's actually installed on all the systems where it needs to be. It's surprising how often that doesn't happen.
Right, right.
Um,
Agreed.
you know, Make sure your audit logs are properly configured. By default, Windows does not log certain things, and those things are very valuable when it comes to dealing with an incident and figuring things out, right? Like file access.
Right.
Knowing who accessed a file when matters. But if you don't turn that on, you may not know. So, looking at that and making sure you're prepared to investigate an incident is important. If you find out after the fact, then you have to bring in a forensics firm who does the best they can. But a lot of times the data is not there, and what you get is an opinion, and you say these are the facts that have been observed, and in our opinion, this is likely what happened. But you don't know for a fact unless you've gone through the work ahead of time.
Right. So I want to talk about timeline, urgency, legal implications. But before I get into that, so these rules are not affecting our ability to detect an incident from happening. Meaning,
No.
we believe at CDI that we should all be following a zero trust strategy, right? Where we're
Mm-hmm.
making sure that we have least privilege access, we have diversified telemetry sources, we're correlating that, normalizing that data, and having a contextual response. The element around, left of boom, as we call it, is not in question here, correct?
Correct.
Okay. All right. So that's good. And then that's, perfect segue. So what is the timeline and urgency from, the SEC? So I know these rules were recently released, right? I think currently there aren't fines being levied, but what is the timeline and urgency for organizations to sort of start looking at this seriously?
So we have one timeline that's written, and the written timeline is the 4-day, runway basically after an incident's been determined as being material before you have to notify the SEC. But that implies a lot, right? In order to meet that window, you have to be practiced in what you're doing and have all of the things in place ahead of time. Just like you have to disclose certain information in your annual filing. If that filing is December, then your runway is a few months here, right?
Right.
From a realistic perspective, what you want to be able to do is determine a materiality in, I would say in less than a week,
Right.
right? Um,
And Josh, my
yeah.
question was more around, the SEC has released these rules, as far as consequences, like how much time do we have, right, before fines would be, levied on organizations that aren't meeting this, right? Can you talk a little
Okay.
bit about that?
So, okay, we need to be clear
Hmm.
that fines being levied are retroactive. Okay, so the answer to the question is when will we know about fines is
Hmm.
probably sometime next year, quite possibly late next year, because
Okay.
the SEC has to go through their process. But the rules are in place now. And that means that if there's a breach now that is not properly disclosed or that is found to be negligent in one way or another, fines next year could be levied against the issue that happened now.
So are there any legal implications?
Well, I'm not a lawyer and I can't give legal advice. Um, so, yes, there are legal implications. What those are and how they affect to a particular organization needs to come from counsel, not from us.
Excellent. So if we look at the transparency and public perception, right? How do you think these new rule disclosure requirements will affect the way investors and the general public view companies?
So, realistically, this is new, and I think investors for the next few months are going to overreact, right? Um, you're going to see, stock being sold for less. We're going to see drops in stock price when one of these things comes out. Um, we will eventually get to the point, and my gut feel is by mid next year, where the analysts that help price, the market, will be able to read these filings and go, oh, this is reasonable. We've seen a lot of things that happen like this. It doesn't really affect profitability, so we're not going to deal with it. And there'll be others where it does affect profitability, right? And you'll find situations where the disclosures will be wordsmithed in particular ways to hide certain information, and we'll start to learn how to read them, right, as we get more of them and we work our way through the process. We will also have situations, as happened with the Progress software, the Move It vulnerability, where you get a series of releases. Now, for them, they were releasing patches and they were giving vulnerability information because they write the software and they have to do that. But if you see, for example, a particular public company release one of these and it looks reasonable, and next week they release another one, and the week after that they release another one, then I think you're going to start seeing some issues. But that's the world we're heading into. We're not going to know what it really looks like until sometime next year.
Excellent. So if we look at comparisons with global standards, for example, GDPR in the European Union, they
Mhm.
sort of led the way as far as regulations are concerned in
Yeah.
that particular category. How does these rules compare to what other countries are doing as it relates to regulations around cybersecurity incidents?
It's completely different. Um, so GDPR is a privacy regulation that is focused on data minimization and protecting data throughout the entire life cycle. And it was put forward because of Europe's history that they have had issues with privacy that have been catastrophic for certain populations in Europe, and it was really put through as a we have to protect people model. The U.S. laws at the state level, some kind of align to GDPR, some kind of don't, and it's a patchwork across the nation, right? Some states don't even have anything. Some states have really strong rules. Some states have really weak rules. At the federal level, we have this from the SEC, and we have HIPAA, and it's different, right? HIPAA is really old now. There are things in HIPAA that don't make sense in the modern world. There are a lot of things that should be added to HIPAA that just aren't there. And we have the SEC that focuses on the public markets. And if you're not a direct participant, then this isn't going to affect you directly. It'll come through contracts with the people that do participate there. And then you have the federal contract space where you have requirements that come in from a different direction. And I expect we'll see alignment with the SEC, but it's not there now because the act that came out last year said that the heads of each one of those sectors I listed off earlier will come out with specific rules, and we're still waiting on those rules.
Got it. So, do you foresee additional changes or amendments to this rule, or perhaps new regulations that may further shape cybersecurity practices in public companies or beyond?
Yeah, I think we're going to see this serving as a model for a lot of the federal rules when they come out, right? I think we're going to see. I mean, it'll be different who you disclose to, whether those disclosures are public, what the timelines might be, and
Mhm.
things like that. But I think we're going to see a general expectation that if there's an issue, you should disclose it to the people that could be affected by that issue. Now, what specific form that takes is really going to vary across the board.
So, a couple questions came in via the chat that I want to address. So, one is around materiality, and the question is around should organizations that are not publicly traded take the reporting aspect out, right? And should organizations modify their incident response plans to take into consideration how material the incident is to their customers, etc.
Yes, I think they should. Up until now, a lot of disclosures have been legally mandated, but the nature of the disclosure really isn't. So it's kind of across the board. There are some that are really good, there are some that are just atrocious. But the thing is, if there's an incident that is material, the people that run the company should know about that, right?
Right.
How can they decide, what to do in response if they don't know the material components? And if a material incident occurs, if you're not a public company, you don't have to disclose it. What would happen if your partners and clients and prospects found out about the incident that you didn't
Right.
disclose? I mean, that'll have a huge business impact. So yeah, you need to consider materiality whatever you're doing. You're just only mandated to do it in certain areas.
No, that makes sense. And there's a couple questions, around how we do that. The same person, how do we take into consideration materiality within, our organization? And, the answer, and we could sort of, have a conversation around this, but, part of what, sort of I see in talking to, CISOs and very large, medium-sized, and even small organizations is that there's a lack of context right? So
Mhm.
I always use Log4j as an example. If you have Log4j running on an isolated system, it's very different than Log4j running on an internet-facing system. And then there's another level of context there. Is that a tier one application? Is it not, right? So looking at cybersecurity from the perspective of or mission critical applications and how vulnerabilities are affecting those systems, as well as when something does happen to those systems are different, right? Any thoughts on that, Josh?
So I think that, okay, we're starting early on the materiality curve, right?
Mm-hmm.
I would compare this to privacy maybe 15 years ago. And we now have concepts in privacy like privacy by design, right? And expectations for how things should be handled. From materiality perspective, we need to think about what types of incidents would be material to the business. And that you can take a data focused approach, you can take a service delivery approach, you can take what expectations do clients have approach. You brought up Log4j as an example. I'm going to bring up oversubscription, right? A lot of SaaS providers and a lot of
Right.
ISP will do over subscription, with the idea that they'll never have a situation where all of their clients are using their systems at the same time. Well, there are times when that happens, and when it does service degrades to an unacceptable level in some cases. And I'm not going to name names, but it's happened numerous times over the last few years. So, you know, that would be a material incident. And
Right.
what occurs is the business made a risk, right? The business made a decision to accept the risk that something bad could happen if everybody decided to do that. Those are material decisions, and you know those should be known, right? In general, whether that's in the form of a contract or in the form of a disclosure or what the case might be. But if you have selected a vendor as someone that is critical for you, you need to know what risks you're facing on that.
Right. Makes a lot of sense. Another question, and I think this one's interesting because it's around a topic that we hear a lot about. What will these guidelines influence cyber insurance requirements for non-regulated organizations? And
I'm
and
sure
part
they
of
will.
yeah, right, yeah. So part of what I'm seeing there is you have cyber insurance in some cases dictating requirements around EDR coverage. To your point, whether we have
Mhm.
MFA in place, whether we have a 24/7 monitoring. And so, will you see cyber insurance providers adopt some of these rules as part of their questionnaire to approve or disapprove or decrease the cost of cyber insurance, the premiums?
Well, I wouldn't say decrease, more like hold it steady. But uh, yeah, the problem in the insurance space is a lot of companies jumped in before there were viable models, and a lot of them did a lot of payouts over the last couple of years. So we're really seeing some cracking down, and we're seeing raising of premiums kind of all across the board. Um, will this approach change the premium model? I don't really think so. Will there be requirements in the insurance contracts that you disclose material impacts to the insurance companies? Yes, I believe that will be required. Um, but it's the way the insurance industry works, right? Is you have to model the risk, and we don't have enough data on like SEC fines and things like that. If I now I'm fairly risk adverse. If I were in charge of a security company, I would be looking at the SEC rules in 2 years and seeing what impact it had on the space and seeing if we needed to pull anything in for that. Anything ahead of time, if we were to try to do that now, it's just guesswork. And the insurance industry does not run on guesswork.
Right. Another question came in on third party risk. How does third party risk play into these rules?
So, okay, from a third party perspective, if the third party is not a public company and is not an active or a direct participant in the market, then you cannot rely on this rule to require that vendor to disclose to you things that matter. So it's up to you to put that in your contracts. And if you are acting as a vendor to other companies, you need to expect these requirements to start to appear in your contracts that are coming to you, and just be prepared, right?
Excellent. And then one final question: how can CDI help organizations plan?
Yeah. So for socializing the materiality component, right? CDI has a red team that does, tabletops and workshops and things like that. We can certainly, set something up in that area. If it's a client that's already getting, managed services through modern IT operations, then leveraging, a meeting with, a vCISO could certainly help there. Working on the incident management workflow and the risk management process, and updating those, CDI can definitely help, whether that's through the red team or the vCISO program too. And then developing the market-facing descriptions if you need to work on documenting how material risks are being managed, and how oversight works and things like that. That could also be something that either the red team or vCISO could help with.
Sounds great. Awesome. Well, listen, thank you for your time, Josh. As always a pleasure chatting. I look forward
Likewise.
to seeing you in more LinkedIn Live events. I think these are very helpful at sort of getting the word out and sharing our expertise with the cybersecurity community. Thank you to our listeners for joining. I think we had quite a bit of folks join. So thank you so much, and looking forward to the next one.
Likewise.